In this video, we're going to go through the 8 steps that you must go through after you set up your LLC. I mean, it's great that you've set up your LLC for your property. It means you're taking this asset protection thing seriously, and it's an important step towards protecting your hard-earned wealth. But now what? Are you done? Can you go back to doing what you do best, which is finding the next deal? Unfortunately, the answer is no. So here are the 8 steps. Let's go through them, and then we'll get into the details. Number 1, transfer the property into the LLC. Number 2, observe corporate formalities. Number 3, obtain an EIN. Number 4, open a bank account for each LLC. Number 5, meet with your tax professional. Number 6, don't forget to register with the Department of Revenue and register in any other state you are doing business with. Number 7, keep your LLC compliant. And number 8, get insurance. So without further ado, let's discuss each of them, which I did on RESL episode 60. Number 1 is, once you set up your LLC, you've got to transfer your property into the LLC. I know that sounds kind of like a duh, but you'll be amazed how many people, and I get it, right? You'll be amazed how many people will set up the LLC, do it properly, even and set it up in the right state, because they talk to somebody and they've set it up perfectly, but then they don't actually go and transfer the property from their personal name into the LLC. And if you don't do that, you have zero asset protection benefit for that. You have to transfer the asset into the LLC, and that has to happen before anything wrong or anything bad happens, or it's even worse than that, if you reasonably believe something bad's going to happen. So just because somebody hasn't filed a lawsuit, if you've got a demand letter, or you obviously you've gotten into a car accident and you know the lawsuit's coming, you can't then say, oh crap, I forgot to transfer all my assets into my LLC. Let me go run and do that. You have to do that before the event occurs. Reminds me of my 2 favorite, they're not really asset, well, the one of them is an asset protection quote, but my favorite one is a John F. Kennedy quote, which says something to the effect of, the time to repair the roof is when it's not raining, right? So that's a good analogy of an asset protection strategy and transferring your assets into the LLC. And then the other one is actually a Robert Kiyosaki quote, which is, you've got to put your seatbelts on before the car crash. Right. Once a car crash happens, it doesn't make any sense for you to go put the seatbelts on. And in the US specifically, there's what we call, there's these laws called fraudulent transfer laws, or fraudulent transfer. They actually are laws, but rules where a judge can actually unwind anytime you try and you actually transfer something after a lawsuit's already happened, or most likely once you suspect that a lawsuit is going to happen. So I know it's an obvious one. And look, the other thing I was going to mention on that one, it makes sense because it's not super complicated, but if you've never done it before, transferring the asset isn't just as easy as one would think. I mean, you've got to file, I would recommend either a warranty deed or a grant deed. I would not do a quitclaim deed, but you've actually, each county has their own rules and processes and procedures, and some of them can be really strict in terms of color ink you have to use. And so I get it. My recommendation is usually to go contact usually a real estate attorney. Just a local real estate attorney should be able to bang out a deed for you really, really inexpensively. But if that's what's hanging you up in terms of transferring the property, please call an attorney to get that transfer, because until that happens, you've just wasted all of your time, because you have zero asset protection if you don't actually transfer the properties into the LLC. I know that's an obvious one, but I wanted to touch on it. Number 2 is you want to observe the corporate formalities. Now, with an LLC, the nice thing about an LLC is that they're not as strict as corporations. With corporations, you've got to have board of directors meetings and shareholder meetings and resolutions and all that. It's really, from a documentation standpoint, it's very, very strict. LLCs are a little bit more lenient, so to speak, but you still want to keep some basic things in mind. Number 1 is you don't want to be commingling any of your assets or expenses. And, you don't want to be using your credit card that you have for the business to go buy groceries or vice versa. You want to be showing the world that you are not your LLC and that your LLC is not, which legally they're 2 separate and distinct entities. You've got to treat them that way, right? So you got to be super careful about that. Now, it's not uncommon. I've done it, especially if you, by the way, if sometimes your LLC hasn't even set up yet. So it's not uncommon for you to actually spend, for example, it's not uncommon for you to go to the supply store, Office Depot, and maybe you do use your personal card for the business. And what you just want to do is you want to clean that up. Ideally, you use the card directly. That'd be my recommendation. But for whatever reason, card was declined, you forgot your card, whatever, and you end up using your personal one, you want to submit a formal reimbursement expense. You want to document that reimbursement, and you want to literally have a corporate resolution with that reimbursement, have it in your corporate records book, and then make that transfer back from the LLC to sort of an expense reimbursement, so to speak. The other thing you want to do is you want to make sure that you sign your documentation properly. When you're signing documents, you are signing on behalf of your LLC. You should never be signing a legal document with just your name. So the name of the document or whoever's signing should be the LLC, and then you should be signing your name, comma, your title, which is usually manager or president or whatever title you've given yourself. You do not want to be obviously not signing in your personal name in general, but even if the LLC name is there in the contract, when you fill out your name, it's not your name, it's your name, comma, manager, right? The other thing you want to do on the corporate formality side is you want to have your operating agreement. You want to have an operating agreement, even though one may not legally be required, especially if it's just a single member LLC. A lot of people say, well, why bother, right? Two reasons you want to have an operating agreement. Number one is you still want to have the special asset protection provisions language in there that helps you in the event that you get sued. You want to have what we call charging order protection language in that operating agreement beyond the scope of this video. But just because you legally don't need one, you say, hey, it's just me, why do I need one? You want to have that language in there so that if you ever got sued and they're trying to attach your interest in that LLC, you can show the operating agreement that's been executed that have that specific language that, hey, anytime there's a creditor, you're not going to be able to transfer ownership, all that stuff. The other reason you want to have an operating agreement is because if you don't, then you actually do have an operating agreement. It's in the state. The state has a statute, an LLC statute. And if ever there's a provision in an operating agreement that it doesn't address your particular issue, or in this case, you don't have an operating agreement, then what's going to happen is that it's going to fall back to the state. So whatever your state rules are, that's in essence going to be your default operating agreement. And you never want to leave your business and your asset protection in the hands of the state. So always have you always want to have an operating agreement. And then you want to have these sort of initial, like we call them organizational minutes, meaning once you set up the LLC, you'll see typically it's a 2 or 3 page, probably 10 to 15 bullet point, where you're just doing all the preliminary steps. You're electing the manager, you're releasing the organizer who created your LLC, you're authorizing the manager to set up a bank account. There's usually about 10 or 15 little bullet points that you want to have in those initial resolution. And think of it this way, and I'll finish this up and we'll go to the next one. If you ever got to that day where you got sued, which these days is more if, not when, not if, you're going to, I know it's all digital now, but you're going to be handing over a binder, your corporate records book. Everybody should have a corporate records book. In the old days, it was actually a 3-ring binder and it was up on a shelf. Now, most people, including myself, will have a folder on your computer and you just have it all organized, in digital file form. But when somebody asks you, that's the first thing they're going to ask you is that corporate records book. You don't want to hand over an empty book or a book that just has your organizational documents like your articles and an EIN and maybe an operating agreement. You want to have, your resolutions, you should be having annual meetings of shareholders, not shareholders, of members. You want to be able to show them a relatively thick book, especially if you've been operating for 10 or 15 years. The last thing you want to do is be like, oh, here's 5 pieces of paper in my corporate record. But you want to be treating this, at the end of the day, you want to be treating this company separate from you. And the easiest way to show that is every time you make a decision, you're documenting that in your corporate records book. Before I go on real quick, I thought I saw a question. What about the due on sale clause? We'll get to that in a second. Well, let me finish my points here. Number 3 is you want to obtain an EIN, which is an employer identification number, which is the equivalent of sort of your personal social security number. LLCs and entities have EINs. You have a social security number. You need an EIN primarily to open bank accounts. And we're going to talk about that next. But even if you don't think you need an EIN, get an EIN because you're going to open up a bank account, which is my number 4. Number 4 is open a bank account, even if you don't think you need one, right? And this is really important. Again, you're trying to make the case, or you're trying to show the world that you are separate from your company and your company is separate from you. Especially if you have an LLC that's set up in a different state, for example. It's like, let's say I live in California, I have an investment property in Texas, so I have a Texas LLC. I'm trying to create as many contacts with the state of Texas as humanly possible. I don't live in Texas. I don't have a physical office in Texas. So how do I create the nexus so that if anything were to happen, Texas law would apply? Because I want Texas law to apply, not California law to apply. And one of the easiest way to do that is through a bank account, because the bank account obviously is set up in the state where the LLC is set up. So I would go set up a bank account in the state of Texas. So now I have a bank account in the state of Texas. Plus, again, it creates separation between me and my company. It's going to sound like a broken record, but that's at the end of the day, when you get sued and they're coming after your company, or if the company gets sued and they're coming after you, either one, you're gonna wish you had everything in place that shows the delineation or separation between the two. So get an EIN, get a bank account, even if you don't think you're going to be accepting monies or sending money out, even if it sits there empty. You want to show the world that you are operating distinctly. Number 5 is you want to meet with your tax professional. At the very least, this is something that happens a lot actually, you've got to at least alert your tax professional that you have a brand new LLC, especially us that are creating so many of these LLCs a year. Every time you set up an LLC, you're on your checklist post setup should be, hey, let's make sure I send all the information to my CPA. It may be that your CPA is the one that's going to set up your EIN, by the way, or obtain your EIN. But certainly in businesses, if you're going to make an S election, right, because that's what your CPA is recommending, I mean, you're going to want to touch base with your CPA anyway to determine how you want this thing taxed. But I'm always recommending my clients to do something similar that I do, which is you want to be meeting regularly with your CPA, not only in your individual capacity, but your corporate capacity. I would say at a minimum 4 times a year. I meet with my CPA once a quarter, because you're looking to strategize and come up with a plan of how to minimize your taxes down the road. And so your CPA needs to understand, well, what businesses are you running? What entities are you running? And are there some expenses or ways we can structure things today that will result in a tax mitigation, by the end of the year? As you guys probably know, if you show up to your CPA on April 14th and say, how do I reduce my taxes? That's not going to go anywhere, as opposed to meeting with them in January of the year, and they can anticipate how much you're making, and then they're going to be able to recommend some investments. Number 6 is don't forget to register well, I shouldn't say don't forget. Make sure you're aware that in some states you may have to register with the Department of Revenue. So the Department of Revenue is separate from the Secretary of State. When you set up an LLC, you're setting up the LLC with the Secretary of State. It's usually what it's called. Sometimes it's a Department of Corporations, but that's separate from the Department of Revenue. And not all states, but many states will require you to also register with the Department of Revenue, because they want to make sure that they're getting their taxes and all that fun stuff. You also want to make sure that you need to determine whether you're going to be needing to register in a separate state, right? So again, if your property is in the state of Texas, but you decided to set it up in Wyoming, do you need to register in the state of Wyoming? Or maybe it's a business that you set up in Wyoming, but you live here in California, so you need to qualify your business in California. So just be aware of that there might be some other registrations, whether it's a different department within the state, a completely different state. And in some instances, not surprisingly, California, there's some licenses you may need to apply for and get. Not anything crazy, but for example, my law firm needs to have a business license just because I have, an office, or even if you have a PO box in a particular county, in a particular city. For example, my office now is in San Clemente, but I used to have an office in Newport Beach, and I had to get a business license, right? I don't know, it was like a couple $100. So just be aware of that. There's a bunch of different registrations, not just the Secretary of State where you actually filed the articles of organization. Number 7 is to keep your LLC compliant. Most states, the vast majority, not all 50, but let's say 45 to 50 of them, require sort of annual ongoing maintenance, whether it's a renewal. Some states like Texas don't actually require renewal, but there's some tax forms or tax document, very simple, but sort of statements of financial information that you must file once a year. So just be aware of that, because if your entity falls out of compliance, and especially after a certain amount of time, it may even be delinquent and extinguished, you may not have protection. So that happens a lot when you kind of set something up and you forget about it. And then a lawsuit happens and you realize, crap, there was a wrong address, or I just never got the mail. And so my entity not only didn't get renewed, it became delinquent, and ultimately dissolved it. So the LLC isn't even there. So you want to make sure that you are working, usually it's with your registered agent, but you want to be working with your somebody to make sure that on an annual basis, you're renewing your registered agent that you're going to definitely be using. And you are also filing your annual renewals or whatever it's called in your particular state. And then the last one is, even though you have the LLC, you should always have insurance. I've done some videos before on insurance, and as much as I hate insurance in general, it's a must. Your LLCs, when we're talking asset protection, it's your backup plan. It's your backstop. Your first line of defense is always insurance. No matter how much I beef about all my pet peeves with insurance companies, at the end of the day, that needs to be your first line of defense. And the whole idea behind LLCs is really, if that for whatever reason, the insurance company isn't there, you're underinsured, or they just go bankrupt, or whatever the reason is, you want to have something to fall back on and have these LLCs as your backstop. So I'm sure there's quite a few others, or there may be others that you want to take think through, but these are kind of the 8, probably the most important ones. I'd be curious if somebody wants to put in the chat if there's something else that they tend to do after they set up the LLC that is helpful. I did see, Kenneth, your question about due on sale. I'm actually planning on doing a video on this, so I'll give you a little bit of a preview. Maybe this is a good practice for me off the top of my head, but the due on sale clause always comes up. And here's what here's what you should know. Number one is that there's really 2 forms of due. A due on sale clause is a clause in the loan agreement that basically says that at any time, if you transfer the property or you sell the property to somebody else, they have the right, but not the obligation, to call the note, right? And the reason they have those provisions came in the 1970s, was because back in the 1970s, when interest rates started going up all the way to 18% or maybe even higher, a lot of people were buying real estate with what we call wraps, meaning they buy the property owner bought the property 5 years ago at a 6% interest rate. Now interest rates are at 18. They said, well, why don't I just kind of assume your loan, or I'll just kind of wrap it where I'll make payments to you, and then you can make payments to the loan to the lender. They were literally trying to get around the idea of you having to actually, when I sold the property, actually have to go and get a new loan out because interest rates were so high. So then the lenders put language in there that said, if you ever transfer or sell the property to somebody else, we have the right to call the loan if we so choose. There's a difference between you selling a property to a third party, like a legitimate third party, which then the banks, that's a concern that you should have, a due on sale clause. If you are a creative finance person, or you're doing sort of seller finance, if you're doing anything creative like that, your odds of getting the due on sale clause is real, because if the bank finds out that you've sold the property to somebody else, they may call it. Now, if you asked me 5 years ago, I would say that even if they found out, they probably wouldn't call the note because it's a performing note. Interest rates are so low. Like, why would they call a performing loan? Or if everybody's making their payments, why would they call the note? Now they're stuck with the property. They got to sell it. I mean, it seemed like a nightmare. But to be fair, over the last, I would say a couple of years, the last 18 months, interest rates have gone up so far that a lot of people are holding 3-4% loans. And there might be an incentive for the bank to say, hey, let me call this loan that's at 3 and 4%. And then I can reissue it or force the owner of the property to get a new loan at 7 or 8%. But that's primarily when you're talking about when you're literally selling the property to a third party. What we're talking about is just transferring it to an LLC that has the exact same ownership percentage as the current owner. So if I own the property by myself, I'm transferring it into an LLC that I myself own. Or if it's a property that's owned by 2 members, then I'm transferring it to by 2 owners of the property, I'm transferring it to an LLC that has the same 2 owners and the same 2 ownership percentages. There's actually guidance and this is what I was going to do for the video. I don't have it in front of me, but if you go look at the guidelines for both Fannie Mae and Freddie Mac, they both have a policy of not to call a loan if the loan is simply a transfer to an LLC or a trust or not a corporation, but any entity that has the same ultimate owner of that LLC. That's a policy in their Fannie Mae and Freddie Mac guidelines. Now, does that mean that's never going to change? That, if interest rates go back up to 18%, I can definitely see an argument that those guidelines may be removed, because now there is an incentive for the bank to swap a 3% loan to an 18% loan. I'm not sure it still makes sense for 3 or 4 to 4 and 8. Maybe it does, but right now the guidelines, if you're getting a Fannie Mae or Freddie Mac, I don't think the word prohibited from calling the loan is correct, but I'm pretty sure they typically have to follow all the policies and guidelines. And if you pull the documents from both of those entities, NGOs, not NGOs, I forgot the terminology, but those Fannie Mae or Freddie Mac, you'll see the language in there that says they should not call a loan if it's a transfer to an entity that has the same ownership percentage. But I'm going to put that was a little muddled. I'm going to do a video here. Probably, I thought maybe even doing a live on it. So maybe I'll do a video on it, but that's a great question, Ken, because I know that's something that comes up all the time. Greg, can you speak to the blockchain and NFT concept for a bit? Yeah, I believe I'm in the camp. Let me talk more general and then we can get more specific. I'm in the camp that in the future, and when I say future, not the too distant future, 5 to 10 years, just like you went from, remember the old days, you would get an airline ticket. You used to get a paper ticket. You'd go to a concert, you get a paper concert. Then we moved into having sort of these digital, like on the internet, and you would show them something, right? Then you went, now we're at the stage where we're doing QR codes, like even the menus, right? I'm here at the hotel. I don't even have a physical menu. I have a QR code that I got to take a picture of. The next step is going to be, I don't know if they're going to be called NFTs or non-fungible tokens. That's just a terrible name. They'll be called something else, but everything is going to be a token that's going to live on blockchain. So for example, your airline tickets will be a token, your concert tickets will be a token, your marriage certificate will be a token, your car registration will be a token. The most mundane things that you have will be on a token that's on blockchain, because then you can verify it, right? If you're looking for a marriage certificate, if you're applying for something, say, I need to see your marriage license, and you give them a piece of paper, there's a lot of ways you can forge that. But if it's on blockchain and you've got the token, they can instantly corroborate that you have the token that corresponds to your marriage license. That's going to happen. Same thing with the car registration. The police officer is probably not even going to require your license and registration. It's going to be in the, you're going to show them the token, and that they're going to know that token is legit. So that's what, in general, from a tokenization standpoint, is going to happen in the future. Specifically, though, with blockchain and syndication, which I made a post, actually just released a video on that. It's already happening, but when people are doing syndications, they're issuing LLC units to their LPs, and that LLC unit is going to be tokenized, and that's going to allow for you to start transferring and freely trading those. The same rules apply, so you have to wait a year before you can freely trade your syndication units. But the technology now is there that you can easily transfer your LLC interest, which will be tokenized. So instead of having a 2.3% ownership in the LLC as an LP, I'm going to own 23 tokens of that LLC. Those 23 tokens, I can then easily transfer from person A to person B. Maybe I only transfer 3 of them or 8 of them, or maybe I swap them for somebody else who's got another syndication in the state, or maybe you have resort property, whatever. It's going to be very easily transferred. The technology that now is there. Now, what's not there is the marketplaces, right? So we don't have a stock market or very liquid. There are some websites, there are some exchanges where you can actually put your syndication up for sort of your tokens or your LLC units there, and somebody else can come in there and they can buy them. But the challenge is there's 2 GPs and 5 investors. Like, it's not there yet, but they're building them out. And I believe over the next 5 to 7 years, those marketplaces will become robust enough where it'd be a real benefit for doing this. And I just think it's a foregone conclusion that's happening. I'm already getting calls with people wanting to tokenize, and we've done a couple of tokenizations, very simple, sort of on real estate side. And I haven't even gotten into the whole, I don't want to get on a whole tangent. I haven't even gotten into the whole area of just being able to tokenize real estate in general, fractionalize something, not only just real estate, fractionalize art, fractionalize anything of value. You can slice any asset into 1 million pieces. Each millionth of a piece can be a token. And now you can start transferring those tokens. And with blockchain, you have the certainty of the ownership, which is the key. You have that transparency, and you know who the owner is, as opposed to right now, you can kind of make it all up. But those are kind of my general thoughts. Anna, let's see here. Do you have information about a land trust for asset protection, and whether it's a better form or added layer of protection would that prevent the due on sale clause? So a land trust by itself, a land trust is a non-revocable, a land trust is a revocable trust, which means that in and of itself, it has 0 asset protection qualities, right? In order to get the asset protection, you have to take that additional step of creating the same LLC that we would create in the examples I'm giving you now, and that having that LLC be the beneficiary of the trust versus you individually, right? So you're almost doing twice the work. Yes, it does help you with the due on sale clause automatically. Like, even regardless of the Fannie Mae and Freddie Mac, if you transfer it into a trust, I forget the French or whatever the statute that allows you to do that, but you can transfer that without triggering officially a due on sale clause. I just believe that, number one, it's just extra work and it costs more money unless you're a pro and you can do it all yourself. And you can get the same results via entity structuring. This is where I'm going, right? So I just think it's an additional layer. The best argument I've heard, well, it's always about privacy, but again, We can set up with Wyoming and stuff. We can set up really private entities, and we can set things up where nobody will know they exist. But the due on sale clause, you can transfer. Here's the other thing too. If you transfer the property from X to a trust, that doesn't trigger the due on sale clause. But if you then transfer the beneficiaries, even though nobody can see it, that technically would trigger the due on sale clause anyway. Now nobody can see it. So now you're arguing, well, how would they find out? I've never liked playing that game of, well, how are they going to find out? I get that question every so often. I'm like, I don't know how they find out, but I don't want to go to bed at night trying to freak out as to how are they going to find out. So I know they're really popular in Florida. And, so in Florida, you may want to talk to a Florida attorney, and maybe that's something that would make sense in Florida for some particular reason. But I just think you can set up the same, you can definitely set up the same privacy, and you're going to have to set up that additional piece anyway, because in and of itself, a trust, just like a living trust, has zero asset protection purposes whatsoever. Like a living trust is simply there to avoid probate, to make sure that the assets get passed, without any issues. It's not going to provide you any asset protection. The only trust that in and of itself provides you asset protection is an asset protection trust. And those are typically set up in Nevada, sometimes Alaska. And then of course, a lot of people start setting up offshore trust, but those are irrevocable trusts. So once you set up the trust, once you fund the trust, there's no changing it. There's no like, oh, now I want to change this one. No. That's irrevocable. And that's why they have that asset protection quality, because you can't change it. You literally have granted those into that other company. Oh, what else do we got here? Any other questions about this topic or syndications in general? Yeah, the due on sale clause, I think, is a great one, because that's really something that people typically, that and insurance are the two pushbacks I typically get a lot of times about transferring properties into LLCs. They either say, I just saw this the other day. Somebody, there was an estate planning issue. There was a tax problem. The transfer potentially was going to trigger a lot of taxes. And so the estate planning attorney or the tax attorney was trying to argue, look, you're not really high liability. If you're a good landlord, then if you're doing everything by the book, you shouldn't worry about a tenant. And I'm like, no. People sue you all the time, especially in recessionary times, which is something I feel is closely approaching. That's when lawsuits tend to go up. And so, you do not want to be owning any of this stuff. So insurance is one of the big issues. And the other pullback, of course, is the due on sale clause. Think about, by the way, on the due on sale clause, the other point to keep in mind is, just think about it. If Bank of America suddenly decided to start calling all these loans and actually triggering or exercising their right to call these loans because people are transferring their properties from their personal name to LLCs, nobody would ever use Bank of America again. It was like, oh, don't use Bank of America, because if you transfer it to your LLC for asset protection purposes, they're going to call the loan. So it's very, very, very rare, if you're transferring it from your personal name into your own LLC, that the due on sale clause even becomes an issue. I've never seen it in my practice when I was doing it. I've talked to people who've been doing it for decades. And the most I've ever heard is people say there was 2 instances of where it happened and we got it resolved. It really is more of a concern when you're literally selling your property to a third party and you're trying to negotiate something with that third party, but it's actually a sale to somebody else, like a creative finance type deal. That's when you've got to be more concerned with the due on sale clause, in my opinion. All right. I think that may be it. Yep, go ahead. Go ahead,
So
Anna.
I do have a question.
Yeah.
So in doing a syndication, if you start off with a 506B and then you want to convert it to a 506C, what does that process entail?
So the process, so just not to leave anybody behind, a couple of years ago now, it's been March, so it's been maybe over 2 years, the SEC changed their integration rules, meaning they stopped combining 2 of these syndications. So if you start a syndication, in the old days, if you started a syndication under 506B, and then you decided to change your mind and switch over to a 506C, the SEC would have considered those two separate syndications. They would have integrated them, combined them into one, and said, well, you violated the rules because you're not supposed to advertise, and here you are, you advertise, and all that stuff. So back in March of 2021, they amended the integration rules and specifically allows now for somebody to start a syndication under 506B take up to 35 non-accredited, not advertise, not generally solicit, not have to verify anybody. And then at some point in the middle of the raise, you can terminate that 506B. So whatever today is, I'm done with my 506B. I'm no longer accepting monies in the 506B. There's no trailing documents that have to come in. There's no monies that are about to get wired. Like I'm done. And from this day forward, I can continue my syndication with a 506C, which means I can now advertise, but then I can only take accredited investors and I must take reasonable steps to verify. So it's literally, I call it a pivot, because literally there's a day that you pick, like today, June 14th, I would document that really well. I would make sure there's a written consent. I would make sure that somehow you're able to timestamp that either through a notary or a DocuSign or something that nobody can come back and say, well, that was signed on a different date. But if you have a corporate resolution, in my opinion, that says, hey, today's the day we decided to terminate our 506B, and from this point forward, we're going to do a 506C, and you comply fully with the 506B beforehand, right? So you're not doing any advertising, pre-existing relationship. And then when you pivot, only accepting accredited and taking reasonable steps, then the SEC will not integrate those two. What I do, or we do at the firm to do an extra layer of protection is we do like to create two separate classes of shares or membership units, because we want to be very crystal clear that when you're out there advertising on Facebook or social media or podcast, that you're specifically referencing, hey, we're selling shares B. Right. So it's very clear that you're not selling that into your, in your 506B piece of it, you're selling into 506C. That's not mandated by the rule, but I think it's just extra sort of steps that we like to take. And then, of course, once you do the 506C part, you've got to update the documents a little bit. They're substantially the same documents, but there's the business plan is updated a little bit because, number one, I mean, think about it. Let's say you needed to raise $1 million, but you've already raised 600. Well, now for the 506C piece, you're not raising $1 million. You're only raising 400,000, right? Mm-hmm. And whatever changes and updates we need to make on the business plan. And then in the PPM, there's some additional disclosures that we usually put in there when it's a 506C, having to do with verifying accredited investors. And it's slightly different. And we like to create two separate classes of shares. And so typically we want to make that decision ahead of time. We don't want to, we want to go into it saying, hey, I want to start the syndication with a B, and then at some point I want to switch to a C, and we set it up that way, versus just doing it as a B, and then one day waking up, say, crap, I got a week to close and I need to switch. I'm not saying it can't be done, but I just like, it's cleaner the way I think we've set it up on the front end.
Thank you.
And if you go back man, I can't believe today's episode 60. If you go all the way back to episode 1 of Real Estate Syndicator Live, I started with that premise, and it's actually it's almost like a 2-hour thing. And it's the only time I think I've used slides and a PowerPoint just so I can show it, because it's a little bit kind of like asset protection and diagramming. So if you want to go that episode 1, that's where I do an hour and a half or an hour and 45-minute deep dive into, how exactly it works. But that's kind of the high level stuff.
Thank you.
Thank you. All right, then. Let's see if there's anything else that you guys have heard about. I've done a couple of videos now, but all those accredited investor bills have moved on from the House and are now sitting with the Senate. There's actually 3 of them that have passed. And so I'm not even sure how that works. I need to find somebody who's an expert in that, because I don't know if they're going to combine those 3 bills into one. They're very substantially the same. They've got their slight differences, but I'm pretty excited about that. I think the Senate here is going to, pass those relatively quick. I think in the next 3 to 4 months, we'll have a Senate passing those bills, and then they're going to go back and probably, consolidate those two and get the language thing. But all those accredited investors, stay tuned for that. And then the other exciting thing, which I almost did an episode today on, is the 1031 rules. The 1031 rules, not the 1031, sorry, the bonus depreciation. There was a bill that just came out of committee in the House that would extend the bonus depreciation that's been going down now. This year was the first year it went from 100% down to 80. They're looking to retroactive that and basically extend it to 2026, which would be awesome. Not sure what the odds are of it passing, but my CPA always thought it was going to get extended. So I'm curious to see if at some point the bonus depreciation comes back in full force, where you can deduct 100%. Remember, it's still there. You can still bonus depreciate your assets. You just only get 80% depreciation versus 100. And then next year it'll go down 60 and so forth and so on.